Hi, I'm Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning corporate, technology and intellectual property law firm that also passionately litigates in these areas of practice. In this video, I'll discuss directors' liability for misleading and deceptive conduct. So whilst directors are generally protected from personal liability by the ubiquitous corporate veil, an action for misleading and deceptive conduct pursuant to Section 18 of the Australian Consumer Law, or the ACL, can make a director personally liable. The question of personal liability is of concern to all directors who attempt to strike the balance between governance and entrepreneurialism. So the statutory test for misleading and deceptive conduct is contained in Section 18(1) of the ACL, and it provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive or likely to mislead or deceive. So misleading and deceptive conduct can occur in a variety of circumstances in business dealings, from misleading advertising and inaccurate projections to contractual dealings between parties. It could be as simple as making a misstatement regarding a profit forecast or embellishing the outcome of a contract. So the elements of Section 18 are contained in three parts. A person must be acting in trade or commerce, doing an act that represents something to another person, and that the representations are misleading or deceptive from the perspective of the target audience. As you can see, the scope of Section 18 is quite broad, and directors must be aware of the representations being made by them and their companies. So how can a director be personally liable? Under Section 236 of the ACL, a plaintiff can recover damages from both the company and its directors. A director will be liable for their own conduct as an individual pursuant to Section 18. However, if their company's conduct is in question, a director may be liable as a person if they are involved in the contravention. The key here is if they are involved in the contravention. This definition is notably broad. So Section 2 of the ACL provides that a director will be involved if their conduct satisfies one or more of the following elements. Firstly, they aided, abetted or counselled or procured in the contravention. They induced, whether by threats or promises or otherwise, the contravention, or in any way, directly or indirectly, knowingly concerned in or was a party to the contravention. They had conspired with others to effect the contravention. So in other words, it's quite broad. And the moral of the story is that prevention is cheaper than cure. The misleading and deceptive conduct doctrine as contained in the ACL can be used as a catch-all for various types of corporate misconduct. To avoid personal liability, directors need to take active steps to ensure that the corporations they direct are not engaged in conduct which could leave someone into error. I'm Malcolm Burrows from Dundas Lawyers. Thanks for watching.